Good morning, everyone, and thank you very much for your time this morning. For those I haven't met, my name is Bruce Tureen. I'm the MD of the Contingent Staffing Division of Adcorp, and welcome to our webinar this morning. We are very privileged to have John with us. John is a great friend to the Adcorp Group, and we look forward to what he has to share with us. I think from our point of view, it's a fantastic time of the year just to get our heads around what does the legislative landscape look like for us. I think that there are pieces that are relevant to our partnerships in respect of being a temporary employment service provider and our relationship to yourselves as the clients, but there's also pieces that are important for each of our businesses in their own rights and in terms of what we need to think about. The construct of the webinar this morning, John will come on live now. I have muted everybody in the audience, both from an audio and from a video perspective. We expect John to speak for approximately an hour and a half, at which point we'll switch on everybody's mics and cameras, and we've freed up sort of 30 minutes at the end of the session for any Q&A that people may have. We are recording the session just to inform everybody of that, and if you do require the recording, we will be more than happy to send that through to you. So John, if I can hand over to you, welcome. Thank you again for your time. We look forward to the input, and we'll pick up once you've finished your session with sort of a live Q&A process. So thanks very much, and over to you.
Thank you, Bruce. Good morning, everybody. It's a privilege to be with you. We have a jam-packed session. Bruce, hour and a half at the most. Certainly we need to get through a lot, but I also want to allow for collaboration. So colleagues, we live in a very, very, very chaotic environment. Someone said in an article the other day, we need to be paranoid, because if we're not paranoid, we're complacent. And if we're complacent, we are going to find ourselves in a position where our organizations are not sustainable. Now, I don't suggest that we all panic and become paranoid, but what it does require is just that sense of creative tension to identify what needs to be done and to get on with it. So colleagues, you are going to get so much information today. One of the things that I immerse myself in is the world of labor law, the workforce staffing environment, and specifically, I look forward, I look ahead at what's coming, and then allow my colleagues to anticipate what's coming down the line. But the sheer volume, colleagues, of what is coming down the line means that we need to be extremely specific and selective in terms of what we prioritize. Now, most of you on the call would be very familiar with this. You might not have put a name to it, the Eisenhower matrix. And this Eisenhower matrix is becoming more and more important as we look at very high volumes of legislation, high volumes of digital change, high volumes of a whole range of changes in the world we live in. So as I go through the session, I want to encourage you to not be too concerned about the detail, but rather to look at the issue and to position it and say, is it important and urgent? Well, if it is, well, then you better get on with it and get stuck in. If it's important but not urgent, well, kick the can down the road. You know, maybe there's a law that's going to apply to you and it's potentially only coming up for implementation in the second half of the year. Well, then schedule it. If it's not important but it's urgent, delegate it. Someone else can do it. You've got your core focus. And then finally, we have to learn that when it's not urgent and not important, colleagues, well, then quite honestly, we need to just take it off our list. We've got a whole range of other things we need to attend to. So in the context of the Adcorp Group and my relationship with Bruce and his colleagues and you as many clients, I really find it a privilege to be able to share with you my insights, and I hope that it will enrich and that it will be a catalyst for you to look at the way forward. And also not just to see it as a problem and a burden, but to look at those opportunities that arise through collaboration and how you can best position yourself. So I really don't want to just be an individual who dumps all of this on you. I want to try and unpack it and see how we can deal with it. Colleagues, this is pretty much a storyline. I'm going to spend a few minutes talking about exponentiality. Of course, there are many commentators on this, but I want to make it real, and I want to try and give you a sense of how that applies in the labor law environment. We're going to touch very briefly on the South African context, the current economic, social, political environment we're in, and what it holds for organizations for this year. Of course, the big focus today is the labor law pipeline, and I'm going to hopefully blow you away with the amount, the volume of labor laws and amendments coming through, but even more so, give you a sense of what to prioritize and how to approach it. We're also going to touch on human resources mega shifts and focus areas. You know, the human resources domain is just so volatile at the moment because labor law is largely driving human resources. Then cyber crimes, hate speech, harassment, all those types of things, colleagues, are becoming massive challenges. We've seen many recent cases. And of course, the learning there, and that talks to leadership and culture, is that leaders set the tone. The culture of the organization ultimately drives employee conduct and behavior. So if you don't approach law from a psychological, behavior-driven point of view, you're going to pick up problems with massive consequences, like, for example, losing your certificate of compliance under the Employment Equity Amendment Act. And then finally, I'll pull it together before Bruce opens up for collaboration at the back end of this. So here we go. So colleagues, the world in which we find ourselves is incredibly chaotic. We often talk about polycrisis. Polycrisis means that we have a multitude of challenges all at once. Not like in the past where we seem to have sequential change. Now it happens simultaneously. And let's take a look at the nature and extent of some of this change. Of course, the internet last year, every minute you had 241 million emails sent in a minute. You had 6.9 million emojis sent in 1 minute, colleagues. Those praying hands, those crying emojis, whatever it is. You had 11,000 fake accounts removed off Facebook. The pure volume of engagement is just absolutely mind-blowing. And of course, it's growing. If you look at Netflix, you know, just before I get onto this, it took something like 60 years to get 50 million people onto an aeroplane. It took Netflix 3.5 years to get 1 million users. And it took ChatGPT literally 5 days to get 1 million people onto ChatGPT. Now, Bruce, I must tell you and the colleagues, I'm engaging with a client around their workforce remodeling, and they're asking for me to give them deep insights into the options available. So I thought, well, you know what, I don't know everything. Let me ask ChatGPT. And in fact, I went to Copilot, which is one of the Microsoft embedded artificial intelligence applications. And I asked Copilot and I said, listen, if you were an organization that lived in this kind of world that you see in front of you, would you rather use permanent employment, temporary employment services, or would you outsource? Well, of course, ChatGPT didn't want to commit, but had a very, very good shot at explaining the benefits of each of those workforce models, and ended up telling me that the best model will be dependent on the realities of the organization making the decision. But colleagues, 5 days to get 1 million people onto ChatGPT. When I thought that was pretty much it, on the right, you'll see the very latest statistics. It took Threads 1 hour to get 1 million users. Now, Threads is an application in the Instagram suite, and it literally took 1 hour to transition 1 million people. Colleagues, the behavioral change that accompanies change is significant. The impact on people is huge. You know, if you do not have the cognitive flexibility, if you do not have a broad mindset, but a fixed mindset, then you're going to be the author of your own misfortune. We look at electric vehicles. You might say, but John, that's all technology. Let's talk about something else. Well, let's look at the automotive industry. The electric vehicle sales volumes, you see a similar curve. Uber growth over time, a similar curve. Well, let's take a look at labor law. Colleagues, we see exactly the same trend. From the first industrial revolution, where there literally was no labor law, and it was literally just like, you know, thou shalt not kill, thou shalt not covet your neighbor's wife, you know, etc. You know, then we had common law, and then only in 1955, the first version of the current Labor Relations Act, called the Industrial Conciliation Act. That was in the third industrial revolution, colleagues. Since then, in the 1990s, we had a plethora of new laws, but they were very transactional. You know, you don't have to think really hard, although some people still seem to battle with how to calculate overtime and Sunday and public holidays. But, you know, if the Basic Conditions of Employment Act says it's double time on a Sunday, well, then you don't have to think really hard about that. If the OSH Act says you've got to do an inspection, well, that's it. What we now see moving into this, deep into the the cusp of the fifth industrial revolution, colleagues, we now see labor law absolutely exploding. And if you look at the nature of these laws, which I'm going to take you through very shortly, a lot of these laws are not only transactional, but they build on psychological underpinnings. What I'm talking about are things like the Code of Practice on Harassment, where for the first time, labor law is eliminating and making it an offense to have a toxic work environment. Toxic managers, toxic employees, toxic union representatives, toxic clients, toxic suppliers. They've taken it beyond the employment relationship, and they have legislated your behavior at the workplace. And for good reason, because who wants to work in an environment where you are continuously being undermined, your human dignity is being impacted, and it's just not acceptable. So again, we take a look at the trajectory and we see this exponentiality coming through. And that labor law, even as much as automotive manufacturers, as much as technology, as much as financial services, and every other sector is experiencing this incredible rate of change. Now, if labor law is an interest of yours, you will know that unfortunately, labor law is lagging a bit behind the curve, because every time you need to change job profiles, restructure, you know, change your commission or remuneration structures, it requires quite a process underpinning that. So what we need is we need an environment, in a workforce environment, that is agile, flexible, responsive, and of course in the process where there are high levels of trust. Because if you look at the right-hand side here, colleagues, if you don't have high levels of trust in your organization, then every change that takes place will be characterized by what you see on the screen. That's, of course, the grieving cycle, but people are also battling with this. So when the Employment Equity Act was published, and of course the targets, the ministerial targets were put out there, a lot of stakeholders went into denial. It'll never happen. It's quotas, it's unconstitutional. The Minister of Employment and Labour has just gone too far. Frustration kicks in, and then you have certain stakeholders starting to litigate. So we see some trade unions, we see some referrals to the International Labour Organization saying, well, South Africa's Employment Equity Act perpetuates racial imbalances and racial divisions, and therefore it's a contravention of international labour laws. So you see the frustration coming through, and then they call it depression, but I mean now it's about fear, anger, and you'll notice that is all enshrined in emotions. And that's the point I want to make very briefly. You see, colleagues, these first stages of change in this exponential change environment, these first stages of change are very much based on emotional responses. And when we are emotionally charged, we disconnect our rational brain. And once that has happened, our decisions and our productivity and our creativity and our innovation takes a back seat. So as leaders, we need to ensure that we have embedded emotional intelligence in our workplace, because emotional intelligence allows you to connect with people and say, well, we fully empathize with your concerns around AI. We empathize with your concerns around employment equity. We empathize with your concerns around ARTO, the demerit points. We empathize with your concerns, managers, that you're actually afraid of employees alleging that you're harassing them now that harassment's so broad. But you can't get to the actual work of the day if you don't first connect, empathize, listen, and listen to understand, not listen to respond. As you do that, you then get into the world of the adult, which is you now start bedding down plans of action. How do we respond? And then you move forward, you experiment, you make decisions, and you then go from strength to strength. The unfortunate thing, colleagues, is many companies don't make this transition. Unfortunately, I saw yesterday, for example, the Adcorp Group going into business rescue. And I've got a very good friend who's an executive in that environment. And, you know, colleagues, I can't help but look at this curve and this rate of change and say, has this been a factor in that particular process? Well, let's take a look at South Africa Incorporated off the back of what I've just shown you. Colleagues, South Africa, just unbelievable country, so resilient, but also we've got massive obstacles to overcome. We are preparing for a very bumpy ride. GDP per capita is dropping off. Economic growth, of course, standing at, 0.5, 0.6%. And of course, the Eskom blackouts, Transnet's inability to really deliver at the ports and the infrastructure, and food and fuel prices are making things extremely difficult. And these realities have rolled over into 2024. Colleagues, we then also see a call from the president late last year to say to business, listen, we need you to please delay retrenchment decisions. Given the fact that we've got an energy action plan, we've got a logistics turnaround strategy, we know you're taking strain in many instances, but please, as a corporate citizen, hold back on retrenchments. And the reason I'm raising this is I can feel it, colleagues. I can feel in my profession, I can feel in my engagement with clients, I can feel that pressure is starting to build in the system. Many companies going into liquidation, business rescue, restructuring, and then of course there are companies that are doing well, but they're doing well mainly because they're managing to navigate the complexities and simplify things and to create an organization that is agile and flexible. Well, I hope that so far you are enjoying it, and I hope that setting that context will then flow over into this next very busy slide. And I apologize in advance, Bruce, to your clients, your colleagues. When I look at this slide, I actually feel fatigued because it is just probably one of the ugliest slides, and it's also very busy. Colleagues, this is the labor law pipeline for 2024. Can you believe it? Plus minus 15 amended or new labor laws in the pipeline. Now, to simplify this for you, on the far left, I've got the actual title of the law. I've then, in the next column, got the status of the law. In other words, what is the promulgation date expected? And thirdly, where is it in the parliamentary process? And then on the far right, I'm literally just going to touch, just to be a catalyst for certain thoughts, but I'm literally going to touch on what are possible responses that you need to prepare for as an organization in terms of these laws. So I'm going to traverse these, and I hope that you keep up. I'm going to make work of it and get through it. But of course, the national minimum wage, colleagues, big issue. We see the minister publishing end of last year Gazette. 8 of the 12 commissioners on the National Minimum Wage Commission voted in favor of, as you see on the far right, CPI plus 3%. So CPI currently running, I think it's at 5.1%. It was 5.5, but you're looking at least a 8.1 to 8.5% increase in the national minimum wage. Business argued to keep it at CPI, but 8 of the commissioners representing labor, civil society, etc., voted against that. So it's CPI plus 3, that's what you're in for. The implementation date, of course, the 1st of March. Before I go further than that, I also want to note, and maybe you can make a quick note of this, there was a Quantum Foods judgment last year in which the Labour Appeal Court contemplated what comprises the national minimum wage. What is in that particular calculation? Is it just the hourly rate, or can companies also add in contributions to funeral, maybe provident funds or bonuses that are guaranteed? And surprisingly, the Labour Appeal Court, and I agree with the judgment, they said that the national minimum wage is a consolidation of all 3 of those. It's not just the minimum wage plus, it's a combination of all of those. And I think a lot of companies are now going to undo that and try and go to the lowest common denominator. Well, colleagues, the ARTO Act, as you know, is based on the demerit points. It's been coming for some time. Someone said to me a few days ago, John, do you really think it's going to come in on the 1st of July? And I said, well, you know, anything's possible, but it's been a long time coming. The provinces are aligning, and I think there's a better than equal chance it will come in on the 1st of July. Colleagues, what does this mean for business? I'm just going to give you 2 or 3 insights. The first thing, anyone in your business who needs a valid driver's license is impacted by this if they need that to do their jobs. Now imagine policy-wise what it means. It means you're going to need a policy where every employee who's impacted must mandatorily disclose their demerits at certain thresholds. Maybe it's at 3, 6, 9, 12. Because as an organization, you're going to require this disclosure in order to start invoking incapacity or disciplinary processes. You're also going to have to keep a logbook and see that at a point in time who was driving that vehicle, and you can then reallocate those points not, away from the proxy of your organization. So there's a whole range of issues. What if someone's license is suspended and they then go for rehabilitation to reduce their demerits or to reinstate their license? Who pays for that? Is it no work, no pay whilst they are not working? You see, you need to put this ARTO framework and policy in place. We then look at the pension funds laws, and really what we're talking about there is the 2-pot system. So from the 1st of September, the 2-pot system will kick in, where 2/3 of your fund goes into mandatory retirement savings so that you can buy annuity income when you retire, and 1/3 can be cashed in up to a certain threshold every year. So that is designed to avoid employees resigning to get hold of their money. The impact of the pension funds amendments, of course, is you're going to have to communicate to your employees. You're going to have to look at your fund rules. You're going to have to talk to your trustees, and then you're going to have to enlighten your employees. Well, the big ticket item is the Employment Equity Amendment Act. And interestingly, of course, this was already been signed off by the president. So we call it, it's been assented to. Now, that's very different to promulgated. So the Employment Equity Amendment Act's been signed, but not signed into law. Our information is that the Department of Labour are currently busy redrafting some of the regulations relating to the ministerial targets that they published last year. They're redrafting that. They're going to do more roadshows with the sectors. And our information is that at best, our information is that the Employment Equity Act ministerial targets will be promulgated towards the end of Q2 of this year. There's been a lot of discussion around that and, of course, many dynamics, but I'm going to show you later on what the practical implications are of these ministerial targets using a sector, just to give you a sense of what's coming. Well, the hate speech bill, colleagues, take a look at that. Hate speech bill, awaiting presidential signature. That's literally how far it is. It's literally on the president's desk. And the hate speech bill criminalizes any form of intolerance toward anyone else based on prohibited grounds. So hate speech based on religion, based on gender, sexual orientation, political affiliation, whatever it is criminalized under the hate speech bill. And now you've got an interesting dynamic unfolding, because you don't only have the code of practice on harassment within organizations where it says you shouldn't use vulgar language, you shouldn't roll your eyes at your colleagues. Now you also have the hate speech bill and other laws that regulate external engagements, where maybe one of your employees is found guilty of hate speech toward a client or a supplier or a member of the public, and is then arrested and imprisoned and faces fines and penalties. So this whole issue around behavior is critically important, and you're going to have to get your head around pulling it together. The National Health Insurance Bill, believe it or not, has been steamrolled despite vehement opposition from many, many parties, steamrolled through the parliamentary process, and the NHI bill is also awaiting presidential signature. The estimates are that it will cost 500 billion rand a year. My apologies, Bruce, can you hear me?
John, you're back. Thank you.
Yeah, my apologies. I must have had a surge. So, colleagues, the National Health Insurance Bill, would potentially have big implications. Now, the point I really want to make, colleagues, is the cost of employment is already extremely high. I would highly recommend you hang on to what you got. Wait for this bill to unfold before you add any additional benefits to your basket. Colleagues, the Companies Amendment Bill has got a massive impact. If your company has got a public interest score of more than 500, so John, what's a public interest score? You can Google that. It is a score that you use based on the number of staff you employ, the size of your business, your revenue. If you have a score of more than 500, the Companies Amendment Bill makes it mandatory to disclose your remuneration in terms of your vertical income differentials. So you already see many organizations disclosing the average of their top 5%, their bottom 5%, their highest earners, their lowest earner. And of course, the whole idea is to generate debate in public, in society, around what is seen to be one of the most inequitable countries in the world in terms of remuneration. Even the Employment Equity Act, as you know, is requiring you to have a plan to deal with the vertical and horizontal income differential. So if you look at my action point there, I've got analyze vertical and horizontal remuneration and renew your policies. Your remuneration policies, colleagues, are going to have to be reviewed. vertical and horizontal income differentials addressed through strategy. And of course, you're going to be disclosing what was previously one of the most top secret things in companies. Well, the Tobacco Products and E-Delivery Systems Bill. Now, that's an interesting one. You might say, John, how does this affect us as organizations? Well, in 2 or 3 ways. The first one, remember, colleagues, the current tobacco legislation only regulates cigarettes, not electronic devices. So your smoking policies and your health and safety policies will have to be updated for new definitions of what is an e-delivery, mechanism. Also, it covers both nicotine and non-nicotine based ingestion, as well as new laws and more strict laws around where you may smoke or not smoke, distances from ventilation, as well as other open doors. So once that comes through, it's currently at the National Council of Provinces, if you look at my cursor, and you should start looking at your smoking policies and looking at what needs to change. Well, the Employment Services Amendment Bill, currently at National Assembly, so it's 2 steps away from finalization. Now I want to just take a bit longer on the Employment Services Amendment Bill. Colleagues, this bill does 3 things. The first thing it does is it gives the Minister of Employment and Labour the legal right to set quotas, and I repeat the word, quotas, for foreign nationals in South African organizations. In other words, the Minister of Employment and Labour will be looking at your EE reports, foreign nationals, and will be approaching you, and already companies, multinationals I know, are being approached and being told, listen, you've got 70% foreign nationals, you need to get to 30 by 5 years from now, and that's the first thing. So you can imagine the impact. The second thing the Employment Services Amendment Bill does, colleagues, as you can see, is it becomes a lot more stringent when it comes to the world of contracting and independent contracting and platform workers. Colleagues, we've seen an absolute explosion of platform workers, the likes of the delivery drivers, Checker 60 Dash, Take a Lot, logistics companies with owner-driver schemes, you name it. And really what the Employment Services Amendment Bill is saying is that there are a lot of contractors who are actually dependent for the economic well-being, for the control of the company, and they are going to get greater protections. The third thing I want to just touch on the Employment Services Amendment Bill, colleagues, is the fact that this particular bill is going to also take a lot of, it's going to also implement a lot of action in terms of workforce structuring. It's going to increase regulation in terms of presumptions as to who employees are, etc. So, colleagues, that is a very important bill, and I think many organizations already now, colleagues, I can tell you, I'm working with the Adcorp Group, with Bruce, with his colleagues. We're already sitting with a number of companies who are their clients, and we're saying, how do we address this optimally in order to maintain sustainable, flexible, agile, and meaningful, cost-effective work, but without contravening these particular laws? Well, Cannabis for Private Purposes Bill. Now, of course, we know, colleagues, that workplaces generally have a zero tolerance policy, and there's nothing wrong with that. And there's a lot of case law that justifies you not even having traces of cannabis. That's fine, because the reality is we cannot determine the impairment levels. Cannabis has traces, but not always proof of impairment. So you can still have a policy that says we do not accept even traces of substances. What the Cannabis for Private Purposes Bill does, that you're going to have to revisit in your organization, is this bill allows you to carry on your person a certain weighting of dried cannabis. So it's 100 grams of dried cannabis that you can carry on your person in private. So if you are found walking down your local street and the police services search you and they find dried cannabis in your pocket, as long as it's not more than 100 grams, well, cool, keep going. The problem is employees are going to want to also bring it to work. So you need to be very clear in your policies that despite the cannabis for private purposes bill, you still have a no possession, no traces policy. And of course, what you do in private's in private, but as soon as you step out your door onto the workplace, you are now in the realm of society and their rights take preference. Well, colleagues, the Cannabis for Private Purposes Bill, if you're thinking of changing your occupation, it also tells you how many plants you are allowed in your garden at home based on the number of inhabitants or cohabitants at your house. So if you really want to have a forest of cannabis, well, just invite your in-laws, your kids, their boyfriends, girlfriends, partners, and you can grow a huge amount of cannabis in your own home. Well, the Health and Safety Amendment Act, colleagues, is also tightening the screws for employers. It requires a number of things. It's currently at NEDLAC, so we're still probably about 6 to 8 months away. But the OSH Amendment Act is going to make it compulsory to have a health and safety committee, even if you just have one health and safety rep, not 2 or more. And the OSH Act also takes the words reasonably practicable out. So it doesn't say you must make a workplace reasonably safe or within reasonable steps. It just says you must ensure. So there are a range of tightenings of that. And then, of course, right at the bottom, parental leave. Now, this comes out of that High Court judgment in Johannesburg where a couple, the wife had fallen pregnant. She runs her own business. So the husband went to his employer and said, Bruce, I need to take 4 months maternity leave. And of course, you can imagine the shock in the gentleman's employer's eyes and said, well, don't you understand? Maternity is for the childbearing mother and not for you. And he said, but that's discrimination because I also participate in childcare. I bath the child, I burp the child, I feed the child, I'm awake at night. My wife runs her business. She can't let go of the business, and best you give me 4 months. Anyway, colleagues, the long story short, the High Court not only said that's unfair discrimination, but also broadened it to adoption and commissioning surrogacy leave. So we're just waiting for the Constitutional Court to confirm the High Court decision. And then once that happens in the next 2 or 3 months, well, then, colleagues, the childbearing mother, the adoptive parents, the commissioning surrogates, the other partner who's not childbearing, they all can delve into that 4-month period. Of course, the big headache for companies is if companies have been historically paying all or part of the maternity leave, they can now have the expectation to not only pay the childbearing mother, but the other parent as well within the context of that judgment. So companies are starting to do some financials to say, well, what will the impact of this have? Colleagues, on this slide, I was really just reflecting on last year and saying, well, by now you should have tied down the COIDA Amendment Act. Of course, the big change there was the obligation to rehabilitate, reintegrate, and re-employ people that are injured on duty. The foreign nationals, as CAN's been kicked down the road. Of course, Lesotho and Zimbabwean exemption permit holders now given exemption till November 2025. Cybercrimes Act, colleagues, very, very important to have a cybercrimes policy because it talks about the fact that you may not harass people online on digital platforms, but it also talks about you may not have unauthorized access to or interfere with or intercept communication. So you see this massive impact of new legislation around digitization, the new world of work, the Health and Safety Act also now extending to workplaces, remote work, hybrid work. And then, of course, the POPI Act. This is an act which unfortunately has disappeared into, into the background, but I can tell you now the first 5 million rand fine has already been issued by the information regulator for an organization. It's in fact a government organization that didn't get its house in order. To add to this chaos, we've got this skills framework, which is a mess. You've got end of June this year, the historical NQF unit standard-based qualifications are phased out. And of course, now the new Qualifications Council for Trades and Occupations kicks in, and they are way behind in accrediting providers and registering new certificated courses. So watch out for that. It's got a massive impact. If you've got training centers, it could impact your BE scorecard around accredited training. You need to talk to people like the PMI specialists, etc. at Adcorp, ICANN. You need to get involved and say, how is this going to affect us? And then, of course, I've touched on the parental leave issue, and then PAPUDA. Now, PAPUDA is an interesting law, colleagues. It's been around already, can you believe it, for 24 years. Now, PAPUDA is the Promotion of Equality and Prevention of Unfair Discrimination Act. And this act protects people against external parties from harassment. So one of our clients, who is an HR director, she was getting harassed by a trade union official, not a representative, but a non-employee trade union official. The harassment grew to such proportions that she approached us and said, what do we do? What do I do? He's not an employee, so I can't discipline this individual. The union's not responding to this. What do we do? Well, you get a protection order through the equality court processes around PAPUDA, and you can then deal with that. And immediately when the protection order was issued, the harassment stopped. Now, colleagues, this can apply to anyone harassing another person or being harassed by someone who's not a fellow employee. So I envisage a lot of people ending up in jail with fines. So your incarceration procedures, colleagues, need attention as well, because I think more and more employees are going to get incarcerated because of hate speech, cyber crimes, and so on and so forth. Not just disciplinary issues. Now, talking about discipline, I'm just going to touch on this. I would like to suggest to you that it may be that your disciplinary codes are a bit outdated. If we look at all of the change, my question to you is, in your traditional disciplinary code, where you have absenteeism and related offences, honesty and related offences, you've got hygiene, you've got a whole range of classifications, but have you got human dignity offences, specifically in terms of harassment, hate speech, unfair discrimination, and cyber crimes? In my mind, you need in your disciplinary code a whole section on that. Inappropriate use of social media and other platforms. We see a lot of case law coming through around electronic communications and employees that are using social media, even in their private capacity, but which ultimately have a link back to the workplace. And then, of course, breaches of POPI, cyber regulations, and the like. So, colleagues, make sure that your disciplinary codes are updated. In future, you're going to have to add ARTO, the Road Traffic Offences Act, for people that do not disclose their demerit points, or they do not disclose when they have suspended licenses, etc. Well, it is a mouthful, isn't it, colleagues? A lot to think about, and that's why I shared with you the Eisenhower matrix, because you need to take all of this and synthesize it and bring it through that particular filter. The net result of all of this is organizations looking at their workforce modeling and their costs. I made a statement earlier, colleagues, that the biggest disaster would be to have a fixed mindset. The biggest disaster would be to be complacent. We cannot be complacent. We've got to continuously remodel our workforces, because in this environment, literally overnight, you could have a significant shift in cost, in flexibility, and in terms of skills, etc. Now, when we do design thinking as part of this process, there are 3 criteria that I would highly recommend you look at when designing your workforce model. The first question is this workforce model desirable? So let me make it a bit more practical. If you want to employ someone, or if you want talent to come through your front door, you've got only 3 options, colleagues. You can either employ people directly, in which case they're on your payroll and your headcount. And if something goes wrong, the buck stops with you. You could go the temporary employment service route, where in the first 3 months, as a general rule, the TS is their employer. After 3 months, there's a co-employer relationship, and there's more than enough labor law to say that the TS still remains the primary party for payrolling, disciplining, workforce management. There's no problem with that. It's just that the client is involved in that particular process. And then thirdly, and the final option is the independent contractor. And what I find so amusing is that people think there are more options. They'll say to me, John, what about you know, the owner-driver? That's a different relationship. I say, no, it's not. An owner-driver is an independent contractor relationship. And they say to me, but what about Fiverr or Elance, these platforms? What about Checkers 60, the scooter drivers? Well, they are maybe independent contractors, but it's not a separate type of contract. Functional outsourcing, managing service providers, those colleagues are the only 3 ways you can bring people into your organization to get the job done. They each have pros, they each have cons, they each have different liabilities. Just take a look at this. Look at this matrix over here. You know, if you employ everyone yourself and you look at all these labor laws coming through, well, then you're it. If something goes wrong in skills, you're it. If something goes wrong with UIF, you're it. If you use a TES, well, you can see the TES picks up a whole range of either several or joint liabilities. And if you subcontract or outsource, well, then the contractor is liable. You know, as I said in this little diagram over here, the buck stops here, you know. So with independent contracting, the buck stops with the contractor. With TSs, the buck stops with both of you to differing degrees. And with traditional employment, the buck stops with you, the employer. So when we talk about evaluating your workforce, colleagues, it's going to be a hybrid of those 3. The proportion with which you use direct TS and independent contracting will change from time to time, but fundamentally the water must find its level. And where does the water find its level? It's in the answering of these 3 questions. Is it desirable? Is it desirable to have 3,000 permanent drivers in a logistics firm with no TES and no outsourced drivers? Is it desirable? Secondly, is it viable? In other words, does it make financial sense? And thirdly, is it feasible? In other words, does the law allow you to structure something like that? Or does the technology enable that? And it's in these 3 areas, colleagues, that I would highly recommend you use that as a basis for designing and collaborating around your workforce model of the future. Because if you look at what I started with today, I started with talking about change in automotive, change in retail, change in labor law, change in every aspect of our lives. What means is we need agility to increase, and we need risk to drop. And we need to be benefactors of these changes rather than victims. We need to be beneficiaries of change rather than victims. And here are the 3 models: direct, indirect, TS, or indirect independent contracting. Now, you don't have to be exceptionally bright to see you can't just do any one of these because it's probably not the right model, but you also don't have to be bright to see that you need to have a mix of this, because the higher you move up this value chain, the lower your head count because you're now being invoiced rather than payrolled. And secondly, your headcount drops, and then, of course, your procurement increases, your risk levels drop, and your agility increase. And when we look at the cost of employment, things just like minimum annual leave, 15 days, sick leave, 30, family responsibility leave, 3 days per annum, public holidays, 12 public holidays. And now we're adding on severance pay. Then it's going to be the National Health Insurance Scheme. And then it's going to be the National Social Security Fund. And then it's going to be who knows what not, this parental leave. Colleagues, before you've actually wipe the sleep out of your eyes, if you employ someone, you're already in for their basic salary plus 20% as a minimum. And it's only going to get bigger from that particular point. So given that reality and given these opportunities, the fundamental question has to be, is it feasible, desirable, and viable to continue to be structured as we are? Now, I apologize in advance, but I'm a very visual person. And colleagues, and I am being a bit of a devil's advocate here, and I apologize for bringing the coronavirus into it. But if you generally had to make a decision, which of course ChatGPT, as I said, didn't want to make, but if you had to make a decision saying, should I rather procure my skills? Should I rather procure services, facilities management, cleaning, temporary employment services? Should I rather procure it and get an invoice where I can drive productivity, service levels, be flexible, open the tap, close the tap, mobilize, demobilize? Should I rather procure or do I employ? And I can't help but visualize that as an employer, I would feel very, very, very concerned to employ more people directly than I need to. You're always going to need some direct employees. But colleagues, in this world that we're in, with all of these add-ons, all of these complexities, I'm not sure it's sustainable to have most of your eggs in the direct employment basket. Having said that, of course, we know that there are certain legal parameters when you design your workforce. This is a wonderful, wonderful slide that I took from the South African Revenue Services and modified. But colleagues, this slide gives you indicators of employment relationship versus independent contracting, because many companies have been found lacking in terms of being a smokescreen for what should be an employment relationship, but is actually, should be employment, but has been positioned as an independent contractor. And these are so good because they talk about near conclusive, persuasive, and relevant indicators. So near conclusive indicators of employment means that the employer controls, the employer pays for time. It must be that forklift driver that comes to work. You can't send your mother-in-law in if you don't feel like going to work one day, etc. So the economic dependence is on the employer, but then you also get indicators of independent contracting. And these are all factors that we can use innovatively in helping you design your workforce model of the future. Colleagues, I also indicated at the outset I was going to share with you the practicalities of the employment equity ministerial targets. I've had the opportunity to conduct research for a client of mine into the wholesale and retail sector, and I just want to show you some insights and what you can expect under the employment equity targets. So I chose the research for the wholesale and retail sector. I hope we have some W&R clients on this call. And the wholesale and retail sector, if you look to the right-hand side, colleagues, right at the bottom, there are 27,000 companies that submit employment equity reports every year. 27,000 companies that have more than 50 employees or whose annual turnover exceeds the threshold. Now, those 27,000 companies employ 7.079 million employees. The point I'm making is if you take a look at the wholesale and retail sector, and I'm actually busy doing it now for the automotive industry as well, but the W&R sector, they have 3,959 organizations that are reporting on employment equity. And of course, that would include the likes of ShopRite Checkers, Dis-Chem, Woolworths, Massmart, etc., etc. So you've got almost 4,000 companies reporting every year, and that are subject to the ministerial targets that are coming through. They employ collectively 895,000 employees. So what I set out to do, colleagues, for my own interest in particular, was to say, okay, if we look at the current status of top management, now let's just stick with me over here. So we've got top management in the W&R sector. If you look at African male, for example, the ministerial target for African male by 2029 is 21.7% based on last year's published draft regulations. So African males by 2029, all things being equal, should represent 21.7% of top management. Their current status is 5%. So there is a 16.7% deficit in terms of African male, and there's a 10.2% deficit in terms of African female. When you bring it back to actual numbers, it translates into 1,197 additional top managers and 731 additional top African female managers that will be required. So when these overrepresented categories, colored, Indian, and white, when there's staff turnover or opportunities for recruitment, these companies are going to have to prioritize African male followed by African female. So collectively, they're going to need almost 2,000 African top managers. If you go down a level to senior management, the number gets to 5,000 senior African colleagues as senior managers. Middle management then goes to 15,000, and then of course the cherry on the cake, junior management, a shortfall of African males of 20,324 African males and 12,626 African females. Now, colleagues, if you add all these management levels up, you get to more than 50,000 African male and female colleagues that would have to be ready to enter junior management or to progress within the occupational hierarchy through career and succession planning. That, colleagues, is an opportunity and a threat. The opportunity is to say, we are one of those 4,000 designated employers. We're going to take this by the scruff of the neck. We're going to take a look at our next 5 years. We're going to introduce learnerships, internships. We're going to introduce apprenticeships. We're going to have bursary schemes. We're going to make sure we collaborate with our partners, get the right skills in. We're going to tap into the TES pool. We're going to tap into whatever resources are there, but we're going to make work of it. We're going to do skills audits. We're going to do career planning, succession planning, etc. And what you don't want to do is to have an increase in your headcount, because if your headcount increases, then all of these numbers also increase proportionately. So if we then take a look at this sector, and I blanked out the company names, you can see there, but I literally took 10 of the top, or I think it's 10 of the biggest wholesale and retail companies in South Africa. And I then looked at what their affirmative action barriers and measures are. And I aggregated them. But if you look at this heat map, colleagues, look at these pink, or rather red and orange areas. These are areas that these wholesale and retail companies are grappling with. They're battling with recruitment procedures. They're battling in terms of training and development. They're battling with experience and succession planning. They're battling with corporate culture. Remember, I've been coming to culture. Culture drives behavior, which drives outcomes. Mindset, very important. We need people who manage and lead with EQ. Selection criteria, remuneration and benefits. The workplace environment, performance and management and evaluation systems. You see, colleagues, if you look at this cluster at the top, it talks to the world of the employment life cycle. It's saying that companies are battling with their pipelines. They're battling to balance and to plan effectively. They don't have career plans. They don't have succession plans. And on top of it, they're recruiting more and more people on their payroll, which makes this more and more complicated. Well, I hope you find that interesting, colleagues. And I have actually gone through this quicker than I thought. I think this is my second last slide. So if you have fallen asleep, this is the time to wake up. Because if I listened to myself presenting Bruce, I would also fall asleep. But I want to end off with a challenge before we maybe open up for collaboration discussion. The challenge I have is the following. We've been talking to you about workforce modeling, and you've got three options: direct employment, TES, or independent contracting. And we know, colleagues, that we need to have human resources metrics that truly reflect the return on investment of how we use a mix of direct TS and independent contractors. You see, many companies, of course, especially multinationals, they had a certain headcount that they couldn't exceed, and then they would sort of hide some headcount away in TES, or they'd hide headcount away in contracting. Other companies, you know, would look at only their metrics around who they employ directly. So cost of employment, revenue per employee, etc. But that also doesn't give you the full picture, because we don't just have employees. We have very much part of our value chain as TSs and independent contractors. So this is a formula that I use with often starting to diagnose and advise my clients around their workforce profiles. And the formula basically looks at your organization's revenue. Okay. So think of your organization's revenue, R1 billion a year. But before you involve that, you look at total expenses less staff remuneration and benefits. So you look at your operational expenses, your operating budget, but you extract from that your staff costs, remuneration and benefits, and you then divide it by your staff costs. The revenue less that divided by that will then give you a number, and it's normally between 1.2 and 2.8. That gives you the return on investment for each R1 that you spend on directly employed staff. In other words, it will tell you holistically whether or not your workforce model and the proportion of people you employ across these three options is generating more or less return on investment. If you go back 3 to 5 years, colleagues, and if you align it with your human resources practices and your workforce profile, you will see some incredibly interesting trends. Well, that was a mouthful. Just before I hand back, Bruce, to you, we always appreciate feedback. If you have a QR code, we'd really appreciate a bit of feedback from you. But Bruce, I'm in your hands. I have gone fairly speedily through this, but over to you. Thank you.
So John, thanks very much. It was most enlightening. And I think, 2 points that I took out. There's a lot for ourselves to consider. There's a lot for everybody to consider. And it's to make work of the ones that are important for us, and to make sure that we have coverage and that we're working in front of the legislation as opposed to being caught unawares. To everybody on the call, again, thank you for the time. And John, thanks for the past hour. If anyone does have a question to ask, please feel free to sort of raise your hand. You can put your video on, and I have given access back to everybody in terms of videos and mics. Alternatively, ask a question in the chat box. If there is something that you want to engage on sort of post the meeting, please feel free to send any of us an email, and we will make sure we get back to you. We will make the recording available for anyone who may want to sort of share it further into their teams or utilize it as a reminder for some of the questions that you may have. Thanks very much.
Bruce, being
John,
an independent contractor, I get paid for output, right? So if we leave after an hour, you're not going to dock my fees, right?
Yeah, guys, is an expensive resource. Take advantage of this opportunity to ask John questions. It doesn't come readily. I appreciate that people may not want to ask any questions, but if there is anything, am I seeing that people's cameras and microphones are still off, John?
It seems to be the case. If I look at Liani, Vernon, etc., it looks like it's disabled, their camera and their mic. There's a hand. Wow.
I think I've sorted it out. I think I've sorted it out now. Ntobeko, how can we help you? Ntobeko, do you have a question? Okay, we don't seem to have Ntobeko on the call. Fani, I see you put your camera on. Have you got a question for us? You just need to unmute yourself, Fani. Fani, I'm trying to see if I can help to just unmute you.
Jonathan.
Hello, yes.
Okay, thank you. I'm sorry, man, it was there was a section, it's just a minor thing that I want to check. First, you indicated that the recording can be forwarded through to us, correct?
Correct.
Is that the same for the presentation itself?
Yes, it's all
forwarded to us at request.
It will be.
Okay. The one thing I want clarity, which is more for me, I'm just giving my perspective and understanding. The Concord ruling, which is particularly the Lodlo, I think there was Lodlo and Kachalia, and Lodlo was referred to as a majority ruling, and Kachalia, of course, was minority. I want to confirm my understanding or be guided. Lodlo's decision, the matter to be decided by the court at the time was not, was basically about the deeming provision itself, the interpretation of it in terms of the dual, the responsibility or the sole responsibility of the client and the labor broker, which in my understanding, Lodlo advanced the NUMSA position that for the purposes of the LRA, after 3 months, the client becomes the sole employer, while Kachalia would have maintained that the dual responsibility is the correct one for the purposes of the act, not suggesting that it ought to be employees should be permanent after 3 months. That has always been my understanding. Surprised that I've had unions now recently, particularly NUM, that joined my ranks recently, suggesting that the majority ruling meant that employees must be permanent after 3 months. And there was a particular commissioner that I'm not sure that hinted that she believed that. And the matter is pending at the MEIBC. And so I just need some clarity and assurance that my understanding is in line or be corrected.
Thank you so much, and thank you for that well-informed question. Yes, the purposes of the LRA, as you indicated, for purposes of the LRA, as you indicated, the ConCourt majority judgment said that the TS client, the TS. Sorry, colleagues, there's just a bit of background noise.
Because she's a financial director for Africa. She's not a,
Can't go down.
she can't go down.
No.
Right?
Guys, just mute yourselves, please.
I've just muted the colleagues. So, yeah, good question. So the bottom line is there've been, oh goodness, I can send you offline, I can send you a list of at least 15 judgments where the CCMA arbitrators and, of course, beyond, the courts have found that deeming is not substitutionary. In other words, the client does not substitute the TES in the employment relationship. It's purely a deeming provision where the client becomes the deemed employer, but the locus standi, the right of appearance at the CCMA, the right of the TES to fulfill the functions in the LRA, disciplinary grievance matters, etc., those rights are unfettered. And, you know, there's definitely been a bit of an upsurge by re-challenges in respect of the status of the deeming provision. But I can give you an absolute guarantee that deeming is firstly only for purposes of the LRA in terms of Section 198. Secondly, deeming does not mean that the client picks up all the responsibility. On the contrary, the TES is absolutely, because the TES has got locus standi, is also in the firing line. So I'm happy to through Adcorp send you, I've actually keep an ongoing PowerPoint slide of all these decisions, and I can send that to you. And there's also one very recently that confirmed that as well. So I wouldn't worry about that. The biggest challenge is going to be just to deal with the trade union in a manner that, you know, you can try and find some common ground. Thank you.
Madeleine?
Hi there.
Thank you very much. I would appreciate if you forward me the cases, that is the CCMA findings or rulings, awards, whatever the case may be. And
Thanks,
then we
Ntubeko.
can
Madeleine?
discuss this.
Sorry, with all this legislative changes coming for 2024, and obviously all the policies that you're going to have to update, you know, from a practical application, how do you communicate all these changes to your workforce? You know, you can't do training, continuous training. You've got 550 people. So I'd really like to know what to do from that perspective.
Yeah, so a very good question. I'll just tell you what my approach has been, and you know, it may or may not assist you. So, you know, the interesting thing is the law is the law. So the POPI Act, for example, you know, required awareness training, the information officer appointed, and a POPI policy, and you then disseminate that policy, and employees have to, you know, read it and take cognizance of that. When it comes to a lot of these laws, and I'm very pleased you asked that question, and I'm just going to pull up my slideshow again. I want to give you an example of how I'm dealing with it. Let's just take a look at 5 laws. The one law, let's cluster them together. If you look at under the Employment Equity Act, the Code on Harassment, you've then got hate speech, right? You then have the Papuda Act and the Cybercrimes Act. And Madeleine, the common denominator across those 5 pieces of legislation I've just highlighted, the common denominator is they all talk to the fact that you cannot unfairly discriminate, you cannot harass, you cannot incur hate speech, and you can't do any of that online or on any digital forum. So what I've done is I've actually pulled them together into one policy. So all 5 of those laws, where you used to have an employment equity law and a policy, and a harassment policy, and a cybercrimes policy, and a POPI policy, I've pulled them into one integrated policy. because before you know it, people not going to know whether they're coming or going, you know. So one of the ways would be to try and synthesize this. The other thing to do is to just isolate those laws that are specific in giving you instructions that you've got to do awareness training or risk assessments. So let me give you an example. The POPI Act says the information officer has to do regular POPI refreshers and awareness. That's one thing. The Code of Practice on Harassment says that you've got to do awareness training and a risk assessment on harassment. The Occupational Health and Safety Act, of course, as you all know, there's regular interaction in that regard. So what I would do is I would almost ring fence the 3 or 4 statutes that require repetitive refreshers, either when people are employed during induction or every year. And I would literally put that into a 1-hour video, and I would use any platform or any opportunity I could to get it out there. You know, so I just think that you've got to become a bit creative and innovative, use technology where you can. But if we take a look at these laws, so national minimum wage doesn't require a policy change. ARTO, big policy change. So there we better get cracking. Pension funds law is more about communicating and what have you. Employment equity, we're on top of. You know, if we combine hate speech, cybercrimes, POPI, and all those other discriminatory laws into one, we covered. NHI, not really a big policy issue. You know, tobacco. So yeah, Madeleine, I think for me it's about incremental change and using the Eisenhower matrix and say, well, you know, when do you do it and who does it? So sorry about the long-winded response, but yeah, we've got to find ways to do it. And I'm happy to share that 5-in-1 policy with you as well, you know, because the problem is you're going to sit in a disciplinary inquiry one day, Madeleine, and one of your staff is going to have, you know, around a braai committed hate speech, and then they're going to say, but I wasn't aware I couldn't say that at a braai, you know, and then you're going to have to pull out a policy and say, well, you know, the hate speech transcends working hours and it transcends the employment relationship, you know. So unless you've got these documents in place, you're going to battle to dispose of those evidentiary requirements. Was there a rule in place? Was it breached? Was the employee aware of it? Thank you.
Thank you very much. That was very, very helpful.
Thanks, John. Thanks, Madeleine. Tobacco, is that a new hand or is it an old hand? And I see that Monaleli has got his hand up. I just want to check with Tobacco whether that's a new or old hand. Thanks, Tobacco. Thank you, no problem. Monaleli, how are you? You're on mute.
I'm good aside, Bruce.
Yeah, good. Thank you.
Thank you. Okay, mine, John, is on appointment of foreign nationals and that we need to pay for their deportation costs. And yet we do not know how much is that we will be paying, because we've got a correspondence from the Home Affairs NVFS Global that we need to acknowledge or to accept liability on that regard. So how do we go about handling that or dealing with it?
Lady, sorry, are you referring to the Zimbabwean exemption permits and the whole foreign national matter?
Yes, it is basically like, it is more like the ZDPs, yes, that are expiring, the ones that you mentioned that they are renewed until November.
Yes, very good question, and it's an interesting area of law. You know, I've got the chairman of our company, Monaleli, is Johnny Goldberg, and he always reminds me of that case in the Western Cape where a lady called Kylie worked for an escort agency, and apparently her performance wasn't what it should have been, and they dismissed her for incapacity. Now, I don't want to go into the nitty-gritties of potentially how they established her performance was not up to standard, but what I do want to tell you is they dismissed her. And she then took them to the CCMA, and the company argued jurisdiction because they said, look, you know, this kind of activity is not really legal. She doesn't have, you know, an employment relationship. It's an illegal sort of profession, if you want to call it, when you overstep certain boundaries. And the court said, or the arbitrator said at that point, it doesn't matter if someone's here illegally or in an illegal profession. What does matter is fair labor rights. And she was found to have been unfairly dismissed because there was no procedural or substantive fairness. Now, I'm telling you that simply to say that the first thing with foreign nationals and visa expiries and permit issues, you can't just dismiss. So you can't say it's breach of contract. There's no longer an employment relationship. So generally, companies are going into operational incapacity. It's pretty much incapacity, similar to incarceration, where someone is unable to fulfill their work because they're imprisoned. So you go into the incapacity process, you generally would hear the person, then you'd go on to no work, no pay until such time they can present you with the documentation that is required for their legitimacy. And then you have regular review periods, and ultimately you'd say, but we've given you 3 months, 6 months. If you don't arrive by this date, well, then we reserve the right to dismiss for incapacity. So that's the process underpinning that. When it comes to the cost of that process, to be quite honest, I am not aware that it is the employer's problem. Unless you've contracted in your employment contract to that extent, it's not your employer's problem. The last thing I want to say on that is, please remember, colleagues, there's also what they call the Trusted Employer Scheme. Colleagues, this is a scheme that Home Affairs have put into place because of the backlog in processing visas. So what it does is, if you are a company that meets certain requirements, and it's generally bigger companies, if you go to the Department of Home Affairs and you present your credentials, they will do a due diligence, and if you pass their test, they will give you trusted employer status. What it really means is they expedite any form of visa and related matter. Thank you for the question. Good question. Thanks.
Thank you, John.
Thanks, Monaleli. I'm just checking in the interest of time for everybody. Is there anyone else who would like to ask anything? If not, just to confirm again, we will share the presentation. I have seen additionally in the chat that a number of people off the back of Ntubeko's question have asked for some of those cases, John. We can perhaps package that and just share some of those numerous examples around the deeming provision with clients. We will send the recording, we will send the presentation, and we'll package those cases at the same time. Again, if anyone has questions beyond, what has been asked today, please feel free to reach out. We'll do our best to respond, relative to the resources that we've got. John, thanks again very much for your time, and thank you for everybody for participating. I think it was a great session. We will do more of them with a variety of different speakers, but it was well worth it this morning. So thanks again. Thank you, everybody, for your time.